Good morning. It is immense pleasure for us to invite our attorney, Greg Mitchell. Greg Mitchell is a civil attorney specialized in tax, bankruptcies, and estate planning and other, applicable laws in Texas. Also with us, CPA, co-founder and CEO of Havan Tax. Then we have Anish Joseph, CPA. He's our director and stationed in Houston. Please tell us a little bit about yourself.
Sure. Thanks, Frixmon. I appreciate the opportunity to talk. I've been practicing for just over 25 years now. I got my law degree from SMU in Dallas, and then I got what's known as an LLM in tax from New York University in New York. And when I came back to Dallas from that LLM program, I started my legal career here locally at American Airlines, where I learned all about taxes and the airlines. I quickly after that went to work for a big accounting firm, Pricewaterhouse, now PricewaterhouseCoopers. That kind of dates me a little bit, where my practice took a turn into state and local tax and then into some systems work related to state and local tax. And for many years, I traveled around the country working on systems implementations. Finally got tired of traveling, went out on my own in 2004. My practice evolved over the years so that at this point, even though I still do a good bit of tax work, my practice primarily focuses on bankruptcy work. I've operated my own practice for about 15 years until about in the last 6 months, I've joined a firm. Ironically, it's a firm that currently primarily focuses on tax, so we have a lot of common backgrounds, but they wanted to expand in the bankruptcy area, and I found them to be a good fit for my practice. So now I'm a principal in Human Law. Their main office is in Frisco, but I operate what is now their Dallas office in Dallas.
Very good, very good. Prem?
Thank you, Greg. As you mentioned that your expertise in the bankruptcies. So under a current situation, all these individuals and business people are going through these hard situations. So they might think about, or they might have a lot of questions about the bankruptcies. Would you please shed some light on a bankruptcy and when should they file it?
Sure. That's one of those questions where you get the attorney answer. It's a definitive. It depends. I guess I would start with consumer bankruptcies, individuals. If a foreclosure on a house is imminent, then the answer is obvious. But bankruptcy can halt foreclosures. I would note that at least right now, most federally backed mortgages have suspended foreclosures, but private mortgages aren't subject to the same rules. And it's also not clear what rules will be in place once the foreclosures are suspended. Many private mortgage companies are agreeing to suspend payments, but they're then requiring all those missed payments be made immediately upon the expiration of the forbearance period. So, an imminent foreclosure is one clear sign that it's maybe time to file. If your car lender threatens repossession, that may be a trigger. Keep in mind that in case of a car, you can actually get your car back even after repossession if you act quickly and file for bankruptcy. There's a lot of people, lenders out there that are shocked to find out that they have to give back a validly repossessed car. And even worse, if they don't do it quickly, they could be subject to sanctions and attorney's fees for refusing to do so. So a few other things, if you only have unsecured debt like credit cards or medical debt, you have more options. In that situation, there's no absolute requirement to file bankruptcy immediately. And if you have no assets, then the worst thing creditors can do is get a judgment against you and call you day and night. Now, for some people, stop calling day and night's enough to file. For other people, the trigger is a lawsuit filed by a creditor. I would file long before you have to dip into your retirement savings. And several reasons for that. Number one, I think the obvious, you give up your retirement savings. Number two, you're effectively converting what was once an exempt asset, the retirement funds are exempt, into a non-exempt asset. That cash in your bank is not exempt. And then finally, third, because you're also going to incur a tax that's not going to be dischargeable when you do so. Pulling money out of a retirement account early generally triggers a penalty tax. And taxes are much more difficult to discharge in bankruptcy. So if you can avoid having to dip into retirement funds, I would say do so. File bankruptcy before you have to do that. There may be some other scenarios where it makes sense to wait because of certain bankruptcy rules. They have to do with purchases you made in the last 90 days. You may also want to wait because you've got a tax refund coming. That tax refund may not be exempt, so if you can wait and go get the money and then do something with it that'll make it exempt, or maybe spend it on something that needs to be purchased. And you also may want to tax can be dischargeable, and we can talk about that in a little bit. I guess real quick, as it relates to businesses, when to file, the answer kind of gets even more complex, a variety of factors, but the general analysis is still the same. That focuses on, what assets are at risk and what urgencies are there. So let's say, for example, you're a restaurant and you've got monthly rent of like $20,000 and you haven't been able to pay because of the pandemic. People aren't eating out. If your landlord's not willing to work with you and they're about to start eviction proceedings, then that may be the time to file. Businesses may also have secured loans out there where the lender's getting ready to foreclose on the collateral for those loans. Maybe a lender has a lien on machinery and equipment you use in your business, and you can't operate your business without it. So that may be a trigger point.
Next question, Anish.
Yeah, you touched a lot of topics, and you said you will touch on the topic of tax debt. So, how can we get the tax debt discharged in case of bankruptcy?
Yeah, that's one that I get a lot for people that have a lot of tax debt that they would obviously like to get rid of and get discharged. Generally, tax debt can only be dischargeable if it's old enough. And for the benefit of anyone listening, I'll go back and explain real quick. I don't want to assume that everyone knows what a discharge is. A discharge is kind of the primary goal of a consumer bankruptcy case. When an individual files and completes a Chapter 7 bankruptcy case, they get a discharge. That discharge acts as an injunction against former creditors from ever being able to force you to pay that debt. They can't call you, they can't sue you. Now, of course, there are no rules to prevent you from paying back any debt, but the discharge makes it to where you legally are no longer required to pay back those debts that are eligible for discharge. And that's obviously the goal. So coming back to your question about the dischargeability of taxes, taxes are only eligible for a discharge after they're more than 3 years old. And that 3 years is determined from the time when the tax return for the year in question is filed up to the date that you file for bankruptcy. So let's say you filed your 2017 tax return, and that's the big debt that you want to discharge. And you filed it when it was due on April the 15th of 2018. Well, if you file bankruptcy today in 2020, your 2017 tax debt is not going to be dischargeable because it hasn't been more than 3 years since the day you filed that return. Now go back 1 year, and let's say you filed your 2016 tax return when it was due on April the 15th of 2017. If you file bankruptcy today, you are now more than 3 years separated from the filing of that return, and therefore that 2016 tax debt is eligible for discharge. A couple of other quick points about those rules. It's important that you look at the date that the return was actually filed, not when it was due. So, for example, instead of filing your tax return, your 2016 return on April the 15th of 2017, if you filed an extension and didn't file that return until October the 15th of 2017, in that case, if you file bankruptcy today, we're in May of 2020, it has not been a full 3 years. And so these are a few of the what I call traps for the unwary, but that's the general framework for the dischargeability of taxes.
So when you say taxes, is there any tax that is not included, or all type of income taxes and payroll taxes?
So most taxes are included in that rule. The property taxes have a slightly different rule because property taxes, for example, attach to a piece of property. And so that's a secured debt, and it's a different kind of debt, and that's not going to be dischargeable. There, for example, payroll taxes, those are different as well because those debts are treated with more of a priority. There's also personal liability on the part of the owner that goes along with those kinds of debts. State and local, like sales and use taxes, are similar in that there can be personal liability. So most of what I'm talking about relates to federal income taxes. There are some other situations where some taxes can be dischargeable, but it can get a little tricky.
So, Greg, as you mentioned that about the Chapter 7 bankruptcy, so could you please tell us about the different kinds of bankruptcies and how these will be useful in different scenarios?
Sure, I'll tackle that one. That one's a little bit of a lengthy one, but here goes. I'll start by breaking it down between consumers and businesses. Consumers generally have the option of filing either Chapter 7 or Chapter 13. Now, an individual can file Chapter 11, and I'll touch on that in a minute, but I'll start with the most common option, Chapter 7 and Chapter 13. Chapter 7 is what we call complete liquidation, and that provides the most benefit for those with large amounts of unsecured debt. And by unsecured debt, I'm talking about credit cards, medical debt. Those are the most common unsecured debts. I typically tell people, if you can qualify for Chapter 7, then it's usually your best option. And there's two reasons for that. Number one, you get the most complete discharge where you don't have to pay any of those unsecured debts back. And number two, it's the quickest. A Chapter 7 case typically spends only about 3 to 4 months, after which you walk away with a discharge and you don't have to pay any of that debt back. Now, unlike a business that we'll talk about in a minute, individuals actually get to keep most of the property that people normally have. Your house, your car, your personal belongings, including things like household goods, furniture, your clothes, your jewelry, your retirement accounts are exempt. Now, there's a cap on some of those items, but most people get to keep most of everything they own. Now, some common assets that you don't typically get to keep are things like a boat or a second home, things that are typically considered to be kind of luxury items. Sometimes cash in a bank account is not exempt, but if there's no immediate urgency to file your bankruptcy case, you can often engage in some, pre-bankruptcy planning that can allow you to deal with cash and bank accounts in a way that will protect it. So, as to individuals, the other most common alternative is Chapter 13. Now, we haven't talked about Chapter 11 yet, but Chapter 13 is basically like a Chapter 11 for individuals. And what I mean by that is, like a Chapter 11 that I'll talk about more in a minute, Chapter 13 involves creating a plan of reorganization. And that plan determines what you pay and who gets paid and how much they get paid. So Chapter 13 plans are a lot more of what I would describe as kind of cookie cutter than the flexibility that's provided by Chapter 11. But nevertheless, Chapter 13 is a lot less expensive. And Chapter 13 certainly has its place in what I would call, a bankruptcy tool belt where you get a lot of different options, if you will. So a Chapter 13 is typically the appropriate choice when you're trying to save a particular asset, usually your home or maybe a vehicle. So if your house is about to get foreclosed or your vehicle is about to get repossessed or has already been repossessed, Chapter 13 is probably your best choice. And the reason being is what Chapter 13 allows you to do that you can't do in a Chapter 7 is to force a mortgage lender to accept a payout of the arrearages that you have on your home. So let's say, for example, that as a result of COVID-19, you lost your job, and now you're 3 months behind on your mortgage payments. There may be a benefit to filing Chapter 7 and getting rid of unsecured debt, but you're not going to solve the issue of the 3 missed mortgage payments. If you were to file Chapter 7, then you're going to emerge from Chapter 7 with a discharge of unsecured debts, but you're still going to be 3 months behind on your mortgage. And if you don't make any payments while you're in Chapter 7, you might be 6 or 7 months behind at that point. So if you instead file for Chapter 13, then you can file a plan that requires a few things. Number one, it requires that you pay your ongoing mortgage payment. And number two, it requires that you make payments in your Chapter 13 plan that will go towards reducing and ultimately eliminating the arrearages over the term of that plan, which is typically 3 to 5 years. Now, although I won't go into it too far, there are sometimes reasons to do both. Let's say you have both scenarios. You have a lot of unsecured debt and you're behind on your mortgage payment. Now, one tool in the tool belt that's not often used is what some people refer to as a Chapter 20 bankruptcy. There's not actually a Chapter 20 in the bankruptcy code, but what that refers to is a Chapter 7 filing, followed by an immediate filing of Chapter 13 once that Chapter 7 is over. So 7 and 13, 20. The Chapter 7 has the benefit of discharging the unsecured debt, like credit cards, medical debt, et cetera. And then after you've done rid of that unsecured debt, you may then be in a better position to be able to make payments on the mortgage arrears without having to worry about that unsecured debt, which also has to be dealt with in a Chapter 13 plan. So that's individuals. Let's talk about businesses. Chapter 7 and Chapter 13 are the most common forms of bankruptcy for an individual. For a business, we have Chapter 7 again, and then we have Chapter 11. So I'll start with Chapter 7. It's similar to an individual Chapter 7. It's a complete liquidation. In a Chapter 7, a business has to immediately discontinue operations. And unlike a consumer Chapter 7, a business doesn't get any of those exemptions. They can't keep any of those assets. So, if there's nominal assets, a trustee may determine that they're simply going to abandon what's there, and the business owner may get to keep, some of that. But anything of value is going to be taken by a trustee, sold, and then those proceeds are distributed to creditors, that money is owed to. Now, since a business doesn't get a discharge, many people will ask, what's the benefit of filing Chapter 7 for a business since we're not getting a discharge? The most common answer is that generally filing Chapter 7 for a business generally tends to prevent future litigation. If a business owner decides they're simply going to shut down, then they do so at the risk of being accused of playing favorites. So let's say they had $25,000 in the bank and they had $500,000 in debt. And so they don't do anything. They just shut down. But what do they do with that $25,000? There might be an inclination to either keep it, take it, or maybe to pay debts of your friends, your family, or maybe even a vendor that you may want to go work for, something like that. Well, when you make those type of choices, you're subjecting yourself to lawsuit by the creditors that didn't get the benefit of those decisions. So if instead of bankruptcy is filed, a trustee is appointed whose job is to administer what assets there are for the benefit of creditors in a way that's deemed to be fair for all. No one is likely to get all their debt paid, but they are likely to get what's fair based on their status and based on what assets remain. So, once a trustee has fully administered a bankruptcy case, what I think of as a bankruptcy approval tends to render any future lawsuits against the business owner much less likely. And then finally, Chapter 11. That was Chapter 7. The other option for a business, and probably what you hear about most in the news, is a Chapter 11. Chapter 11 is a chapter of bankruptcy that a business can file when it doesn't want to go out of business. It wants to keep operating. It just can't do so based on its current situation. And in Chapter 11, the debtor proposes a plan of reorganization similar to Chapter 13, but it's a lot more flexible. You have to send that plan out to all your creditors. And in order to get that plan confirmed, there's a lot of rules that have to be satisfied. But generally, the most important is to get certain required votes in favor of your plan. You don't have to get everyone's vote, but you do need support for your plan from creditors. Usually you get that support if you can convince them that your plan presents the best opportunity for them to get paid, or at least the best opportunity to get the highest percentage of money that they're owed. And in fact, one of the rules that has to be satisfied in order to get a Chapter 11 plan confirmed is that creditors have to receive at least as much as they would in a Chapter 7. So let's say, for example, that your business completely shut down and filed for Chapter 7. If unsecured creditors would only receive 25% of what they're owed, then if you file Chapter 11 and propose to only pay them 10% of what they're owed, then you're not going to be able to get that plan confirmed. So there's a lot of other Chapter 11 requirements, but that gives you a little bit of a flavor of how Chapter 11 compares with Chapter 7. One final note I'll make regarding chapters. I mentioned that Chapter 7 and Chapter 13 are the most common for consumers, and Chapter 11 is most commonly used by businesses. It is possible for an individual to file Chapter 11. It's not common because Chapter 11 is a lot more expensive. It's a lot more complex, but there are scenarios where individual Chapter 11 can make sense. The most common is where an individual doesn't qualify for either Chapter 7 or Chapter 13. Several reasons. It could be the amount of the income is too high to file a Chapter 7. It could be the amount of the debt, because the bankruptcy code limits the amount of debt an individual can have in a Chapter 13. It's a large number, so most people come under it. In the case of unsecured debts, it's like $420,000. In the case of secured debts, it's like almost 1.3 million. So most people don't have that. But if they do, Chapter 11 is worth considering, because it can be tremendously beneficial in the right scenario. But it is more expensive and it's much more complex.